Ladies and gentlemen, 3, 2, 1. Your number one digital radio station. Heart and soul. The heartbeat of the nation.
Good afternoon and welcome to Legal Matters. My name is Tulani Mututa, orator for the law, and I'm coming to you live and direct from the Heart and Soul Studio Broadcasting Services station. Today, I am joined virtually in the studio by Ms. Nompilo Simanje, a lawyer who is practicing around digital rights. And Ms. Simanje, we are glad to have you on the show. Welcome to Legal Matters. May you please introduce yourself to our guests.
Hi, Tulani, and good afternoon to everyone joining us. Thank you very much for having me. I am Nompilo Simanje, a lawyer by profession, but also working as a legal and ICT policy officer for the Media Institute of Southern Africa, to which we do work around digital rights, but more specifically also relating to freedom of expression, access to information, and the right to privacy. Thank you.
Okay, thank you so much, Ms. Simanje, for taking time out of your busy schedule. We are really keen to hear what else you have to say with regards to this issue of digital rights. So, as always, we have 3 exciting segments today on legal matters. And for the first segment, we're going to be talking about the current affairs aspects with regards to digital rights. We are going to try to define what digital rights are and why they matter in 2021. Why is it important for each and every Zimbabwean to know about their digital rights? And then after that, we'll get into a bite size of the law as we talk about the legal institutions around digital rights and also the law around it in terms of the international legislation, regional legislation. And then lastly, we'll cascade into some domestic legislation with regards to digital rights. And then lastly, to close up the show, on our Law in Action segment, we're going to be talking about the importance of digital rights, just trying to show the audience the practicality or the use of digital rights in practice. So, Ms. Simanje, before we get into the first segment, please tell us, what are digital rights? Why are people now talking about digital rights? Where did this come from? And possibly point out a definition that can help me and the listeners understand what exactly digital rights are all about.
Thank you for that question, Telani. So basically, digital rights are human rights. They are the same rights that we exercise offline, but now we are exercising online. So others call them online rights, but in brief, those are what digital rights are. Why are we now saying that there's a need for people to recognize the use of digital rights? Because you're saying these are the rights we have in practice, we have in our day-to-day lives, but then you're now talking about the computer environment or technology, so to say, and then enforcing the rights that we have in the Constitution on a digital aspect or on a digital playing field. Yeah, this conversation is now quite critical. And I think maybe for the Zimbabwean people, it has become more critical during COVID-19, because during that time, we really cut off on all the physical activities that we're doing. So now even the right to education was being exercised online, the right to access information was being exercised online, freedom of expression, communication, the likes, we're now exercising online, freedom of association. So now, as Zimbabweans, we are now critically seeing the importance of digital rights now because of the COVID-19 pandemic. But broadly, as a continent, and also even as the rest of the globe, we are now saying we are living in a digital age. The 21st century is being associated with the fourth industrial revolution, the ICT's revolution. So it's conversations around the development of technology and the increased reliance on technology, which has really made conversations around digital rights quite important.
Okay, you said something there that caught my attention about the fourth industrial revolution. So yes, there is a technological bandwagon with regards to production in the world, and we're going towards artificial intelligence, and just basically we're going to where the world we live in is going to be digital. We are going to be digital citizens in a digital global age. So there we have it. This is what we're going to be talking about today. And as Ms. Simanje has already said, digital rights affect each and every human in the same way that the ordinary human rights also affect each and every human. So is there anything else with regards to current affairs, Ms. Simanje, that you'd just like to relay with regards to this issue of digital rights? Because I understand there are various campaigns that are being undertaken by organizations such as MISA to promote the awareness of digital rights.
Yes, definitely. I think there's so many issues we need to take note of, even more particularly with regards to the legal framework. Since last year, since May 2020, we had the Cybersecurity and Data Protection Bill that was gazetted. We understand it is now awaiting presidential assent, but that is also a law which is very specific to the digital landscape and the legal framework with regards to digital rights, which I think as a country we need to look into. But also more recently, the issue of internet access and affordability to learning. We know that recently, Tel1, Net1, they increased their data tariffs. And there have been so many conversations online around that. So as we think about digital rights, we need to appreciate that internet access and affordability is an enabler for digital rights. So the pricing of internet and mobile data tariffs is quite interesting for me.
It is for me as well, because basically now that the world has gone digital, data has become the passport or the token for you to be able to get online. So what exactly now can organizations like MISA or other civic organizations do to help people who don't have access to data? Because we are saying we cannot essentially say that data is now a public thing. We cannot give that burden on the government of Zimbabwe to say that make sure that you provide data to protect the right of access to information. So what initiatives have been done, or what can the wise student or wise person who is living in the digital age do to have maybe say cheaper access to data? Because without the data, there are no digital rights to speak of.
Well, actually, there are so many issues around this. I mean, when we speak about the data itself, that would be a further issue around this, but the starting point would be the digital divide. I mean, when we speak about internet access, we are speaking about, firstly, the issue of availability of infrastructure. We have people in rural and marginalized communities that don't even have base stations to access the mobile network, let alone internet itself. So these are some of the things that we need to look into, and definitely the government has a role to play. I mean, already the telecommunication industry players have their concerns, but also for me, and also on behalf of MISA, as a civil society organization, we also have our concerns from a human rights perspective. So the government has a role to play, even POTRAS as the regulator of the telecommunications industry has a role to play with regards to that. But also when we move further and speak about the issue of the data itself, there's already an issue around income levels. I mean, we need to appreciate the basic realities of ordinary people in Zimbabwe. How many people in Zimbabwe can afford basic necessities before we move to talk about access to data? So when we speak about data, we need to relate that to, the average salary of an ordinary Zimbabwean. We need to relate that also to the average amount that is needed for a Zimbabwean to access basic necessities. So it's quite a critical conversation. And I think as MISA, what we have done also in partnership with the Media Alliance of Zimbabwe, we did a campaign last year on hashtag data must fall, where we're basically calling on the telecommunication industry players to strike a balance between business and human rights, because clearly we appreciate that internet access is an enabler for day-to-day activities, be it business, be it human rights, be it communication, be it education, be it health. So in light of that, we have done that campaign. We have also engaged Parliament. We wrote a letter, we petitioned Parliament to intervene. And we intend also to engage, because we believe in the power of a multi-stakeholder approach. We have reached out and we still continue to want to reach out to players in the telecommunications industry, to Parliament, to POTRAS, and also to fellow CSOs and consumers for us to have a roundtable discussion on this issue.
Yes, because I feel like those roundtable discussions are really important, because what essentially it means is that digital rights are now a thing of the day. And it's amazing to find that Zimbabwe is actually the country in the Southern African bloc that is some of the highest data prices. So this cascades also into other issues of the economy, because if there are high data prices, it essentially means that people cannot use e-commerce or use social commerce as they are supposed to. So we are also lagging, or we're also losing some advantages there if we do not have ready access to the internet. So thank you very much, Ms. Simanje. That was quite insightful. And I hope for our listeners, we are now on the same page with regards to what constitutes digital rights and also what exactly we're trying to achieve in this field. I also like the fact that there are initiatives that you're talking about, Ms. Simanje, and those initiatives, like you said, are being carried out by civic society organizations which are passionate about this. So be sure to look out for the pages that Ms. Simanje was talking about, and also see how you as a youth can also be engaged in these issues of data, digital rights, and also just make a mark, also contribute to the advancement of digital rights in Zimbabwe. So now that we're clear on that, Ms. Simanje, let's get into the bite-sized law. Let's get into understanding the law around digital rights. Because one thing I want to talk about before we get into this is a right that I saw that's being enforced in Europe, which was really rather something that got me interested, the right to be forgotten. So do you know about that digital right? Where exactly is it coming from? Because I thought it's something that's superficial, but then in Europe, it's something that's being enforced on a daily. So what exactly is the issue with regards to this right to be forgotten, just as a opener with regards to the issue of digital rights?
Yes, so the right to be forgotten is actually something that is very real.
Okay.
You know, others say the internet never forgets, which is true. So now we are moving towards making sure that the internet forgets. So that's what we speak about when we speak about the right to be forgotten, the need to ensure that we protect data protection and privacy post maybe, like, let's say, for example, we have people that are running for parliamentary elections or presidential elections. Then you'll see some content and some issues relating to them, something that happened even 10 years or 15 years ago, still being resuscitated and still being generated into the digital rights or the digital ecosystem. So the right to be forgotten really is that whenever an institution or a person has information about someone for a specific perspective or for a specific objective, that information should be used for that purpose, and post that purpose, that information should be deleted. We have also spoken about that even when we're speaking about our cybersecurity and data protection bill, that even during COVID-19, we have information that is being collected about us. Post-COVID-19, that information will need to be done away with at some stage. So there should be a timeline as to when that information will then be deleted or done away with. Yeah. Okay. So that's, in short, that's what the right to be forgotten is about.
Yes, I think that's really interesting. And just trying to use the example that you gave about, say, maybe a political candidate who is running for office, in as much as there is that right to be forgotten, Ms. Simanje, don't you also think it's important that we should know if they were doing any fraudulent dealings 10 years ago? I'm sure it is a bearing on their character, or it's information that would be necessary before I decide to make a vote. So don't you think there's a contradiction there about, because I'm saying, we need to know this information before we make decisions. And in as much as it's something that's personal and someone wants people to forget about it, we cannot ideally forget about it. So how exactly are we balancing those competing rights?
No, that's quite interesting. I mean, especially for public officials, because obviously there's a higher burden on them as public officials or people that are aspiring to be public officials. But also, I think something that's very important is that we need to appreciate that normally when such information or such data is regenerated in the system, more often that is where misinformation and disinformation also comes into play. More often that is where false news come into play, because sometimes you are then given an impression that it is something that is current, it is something that is ongoing, when in actual fact it's something that happened in the past. So maybe also when we try to balance that, we need to put into play issues relating to fact-checking and information verification. Otherwise, we'll have a challenge around false information, and we'll also have a challenge even around the right to dignity. I mean, when people have moved past something, we need to ensure that we leave some of the issues to rest. But of course, it doesn't take away the fact that for public officials, there's a higher burden.
Yes, and also just as a follow-through question before we now get into the basics of the law around digital rights, are digital rights also limited in terms of the way that human rights are limited? Say maybe in the instance of an emergency or in the instance where it is justifiable in a democratic society, can we say that the government or any enforcement body can uplift digital rights and then do whatever they want to do just because of that limitation clause that is also imposed on the basic human rights that we have?
Yes, because we are saying that digital rights are human rights. So indeed, they are subject to limitation. But I just want to highlight that the limitation should be a limitation that is also within the ambit of the law. And what that means is that that limitation should be justified. I'll give an example of the internet shutdown that we had in January 2019. That shutdown was not lawful. It was not justified. Even the High Court declared the same. So whenever we limit digital rights, that limitation needs to be legitimate. It needs to be for a legitimate purpose. It needs to be lawful. And like you said, it needs to be necessary in a democratic society. So all those principles need to be taken into consideration. It needs to be proportionate to the objective that the limitation is supposed to serve.
Yes, and I also feel like that's really important because the issue of politics and also the issue of limitation of these digital rights is something that cannot be separated. But anyway, Ms. Nompilo, let's now get into the law around digital rights. Let's begin on the international field. What does the legislative framework say on the international arena with regards to digital rights?
So maybe in brief, I'll highlight that maybe for those that might want to look some of these issues up, we have several pieces of legislation. We have reports by special rapporteurs. We have United Nations resolutions. We also have other conventions like the African Union Convention on Cybersecurity and Data Protection. We have the cybercrime model laws on data protection. So we need to also look into some of those. We also have the Malabo Convention, that is the African Union Convention, but we also have the African Declaration on Internet Rights and Freedoms. So those are all pieces of legislation, a piece of laws, soft laws, conventions that are there, international standards that are there on digital rights. But in short, what all of them are saying really is that digital rights should be promoted and should be respected and should be given the same equal protection that is given to rights that we exercise offline. That is the key issue I would want us to take away on international standards.
Just a quick question there on the international standards. I heard you talking about the African Union Convention on Cybersecurity and Data Protection. So my question would be, what then becomes the relationship between data protection and cybersecurity and the enjoyment of digital rights?
That is quite an interesting question, actually. So I think when we look at cybersecurity and data protection, both of these are centered around protecting the right to privacy. And the right to privacy is actually an enabler for exercise of other rights. So you will note that people feel more comfortable to express themselves. People feel more comfortable to associate with others. They feel more comfortable to access information when they are guaranteed of their right to privacy. You know, when there's right to privacy, there's also a guarantee that there won't be any reprisals from their communication or from their association. So the right to privacy is actually what is protected by cybersecurity laws and the data protection components.
All right, thank you so much for that insightful answer. And for our listeners, we're going to also be having another show as a part 2 to the installment on digital rights, where we're going to be talking with Mr. Kuda Ove, who works for Privacy International, so that we will now be zeroing in on the right to privacy and why it's really important for the right to privacy to be upheld. Okay, Ms. Simanje, so now let's jump into the domestic legislation. What does the law say with regards to digital rights in Zimbabwe, bearing in mind that MISA is actually a key player in the legislative process, particularly remembering that your organization actually wrote a letter to the president recently asking him to stay the ascension or the enactment of the bill we have with regards to data protection and cybersecurity?
Yes, so we have, I think when we agree that digital rights are basic human rights that are being exercised online, we appreciate the importance of our constitution as the supreme law, which is providing for all of these rights that we are talking about from a digital perspective. And then when we move from there, I think, like I said, that we have, of course, the Cybersecurity and Data Protection Bill. That law has several provisions that are there that speak to creating safe spaces online, although there are some other provisions which we as MISA Zimbabwe have felt would infringe on digital rights. But also, I think one of the laws that we need to, Tilan, sorry about that, please go ahead.
And what particular provisions are those that MISA has an issue with regards to the bill that we have at hand? Because legal matters is all about explaining these complex principles to the general public. So what exactly was the issue there so that they also understand the picture behind your lobbying?
Yes, thank you very much. So when we looked at the Cybersecurity and Data Protection Bill, maybe I'd want to also get the listeners to appreciate the process that we have been taking as part of our campaign and as part of our work towards influencing and shaping this law reform process. So when the Cybersecurity and Data Protection Bill was gazetted, as Mr. Zimbabwe, we made our submissions to Parliament and to the responsible ministry, which is the Ministry of ICT. And these submissions were based on an analysis of the law that we did. And we noted that it had provisions. Of course, there are provisions on cyberbullying and harassment. There are provisions on issues relating to, revenge pornography, with provisions on, the publication of intimate images and the likes, which we think is quite progressive towards creating safe spaces for women and curbing online gender-based violence. But also we noted some provisions that relate to whistleblowers. The law had a very skeletal provision on whistleblower protection, but we want to appreciate that whistleblowers are very critical and very important, particularly for purposes of transparency and accountability. So that's something we're also taking note of, that there was need to have a more substantive mechanism for the protection of whistleblowers. But also we noted a provision on false news offenses with even strict penalties as well. And our position with regards to the regulation of false news or the criminalization of false news is that it is unconstitutional and it infringes on freedom of expression. And this is stemming also from the fact that there's already a constitutional court order which highlighted the same, that false news offenses promote self-censorship. So that's something also that we were highlighting with regards to the amendment of the law, but also the issues of surveillance, that this law is allowing the use of remote forensic tools, which tools are not being explained in terms of who is going to use them, under what circumstances and for what purposes. So outside such mechanisms and such safeguards, our position is still that we need to have this law revisited, and we need this law to be sent back to public hearings to ensure that it really ensures that it meets its objective to create safe spaces online, to protect data, and to promote cybersecurity, instead of taking back the same rights that we are being given through the Constitution. So those are some of the issues that we are highlighting.
All right, Ms. Manje, well said. But now my question would be, don't you think that the bill is in essence the starting point? Should we not just let the bill sail through and be gazetted as an act, and then after that we can work towards amending the bill? Because as we are saying currently, there is no specific law in the field. So don't you feel like the bill will be a gift in essence, and then we can now move on to amending it so that it achieves those goals that you're talking about?
No, unfortunately not. Some of the key issues around lawmaking relate to, firstly, the involvement of the public participation in the process, which is why we're calling for the law to be sent back to public hearings. But also there's the issue of clarity. If those issues are still outstanding in the law, then the law should not be passed. The law should not be enacted. All those gaps that are there should be filled in so that there's clarity with regards to the law before it's enforced. But also finality in lawmaking. I mean, it's not useful to have laws that we keep on amending, or then that are further substantiated by so many regulations. There should be finality in the lawmaking process. So for that reason, we should be able to meet all those principles before the law can be enacted.
Yes, well, I certainly agree with you there to an extent, because the other thing with this digital citizenship or this digital environment we're now living in is because the changes are so fast-paced, and sometimes the law cannot catch up with them at all the same time because it keeps evolving and evolving. So in essence, we would need to have evolving legislation that makes sure it stays on top of current affairs and regulates the cyber issues as they come and as they go. Okay, Mr. Simanje, very insightful. I am glad to have you on the show, really, because you are demystifying some of these issues like the expert you are. So with regards to the institutions now in Zimbabwe, how many people, how many civic organizations are out there who is doing what with regards to digital rights in Zimbabwe, and how can people get in touch with these organizations so that they can be assisted with regards to contraventions or with regards to enforcing their digital rights?
Actually, there are so many players that are involved in this process. I think I'd want to make mention firstly of the Postal and Telecommunications Act. It's another piece of legislation that is quite key with regards to exercise of digital rights. This law also speaks to the establishment of a universal services fund, which is there to facilitate access to telecommunication services by people in rural and marginalized communities, which I think is one of the gaps that we need to cover with regards to digital rights. So Portras is the administrator of that universal services fund, and Portras remains a key stakeholder with regards to these issues around digital rights. but also because Potras is the regulator of the telecommunications industry. They play a critical role in this landscape. But even the telecommunication industry players themselves, your Telesol, your Net1, your Zol, your Ethernet, all of them are critical players also because they are facilitating the service that enables people to exercise their digital rights. And then, of course, Parliament in the lawmaking process aspect of it, Parliament and their parliamentary portfolio committees. And then, of course, we move to the civil society organizations also as key stakeholders, Mr. Zimbabwe included in this work.
Yes, and also I was saying it's really important that, it's really interesting that you mentioned service providers as key players in the issue with regards to digital rights, because like you were saying, issues of information and privacy, and people willingly give up their information to data service providers. They give out their residential addresses, they give out their identity details. So in essence, I understand why there is the need to include them as key players in the field, and also make sure that there are standards that they are held against with regards to best practices in terms of handling people's data, in terms of handling people's information, and all the 9 yards with regards to digital rights.
Yes, definitely. And so I think with regards to civil society organizations like NISA, we have a duty not only to raise awareness on issues relating to digital rights, but also to influence the lawmaking process itself. And the media, I mean, we are using this Heart and Soul platform right now to speak about digital rights. So we cannot take away the crucial role that the media plays in unpacking these issues, in providing platforms for conversations, for awareness on these issues. So even on writing stories, I mean, the media writes stories on so many issues relating to digital rights, issues of surveillance, issues of internet access and affordability. Those are all key issues that we need to think about, and the media also plays a critical role. So there are so many stakeholders that are involved, even the consumers themselves, because as consumers, we have a role to play also with regards to even issues of digital safety and security. So those are some of the key aspects and stakeholders that we need to.
All right.
Everyone has a role to play, in short.
Everyone does. I was listening to some of the recommendations that you had earlier on with regards to the bill. So I was going to ask you if there's any divide or anything else we need to do in terms of the law, but you had already stipulated that with regards to the bill that's coming out, there are a lot of gray areas that you wish to be rectified. So I think that being said, Ms. Simanje, we can now move on to our last segment, which is the law in action segment, where we are just basically trying to understand the importance of digital rights, because like you were saying, they are equally human rights that are now just being applied in the digital environment. So basically what we're saying is, if you cannot be discriminated against on any grounds in the physical world, then also in the digital world, you cannot be discriminated against on any grounds, whether be it creed, sex, religion. So basically, I'm trying to understand the importance now and where exactly digital rights can take humanity or mankind if they are enforced to the best practices, as you were saying.
Yes, thank you very much for that. I think even in our opening discussions, we highlighted how we have a heavy reliance on the internet. So we cannot take away the importance of digital rights. I mean, access to the internet as part of exercise of digital rights is important for business. We have so many young people that are entrepreneurs, so many young people that are operating online. There are issues of digital safety and security that are all part of the bigger landscape on digital rights. We are transacting online, the safety of our transactions. People are being scammed online. These are all issues that are part of digital rights that we need to take note of. But also we are communicating online. People are making friends online. People are sharing information online. So all of those issues are quite important. During COVID-19, students were learning online. And already we have the Child Online Protection Guidelines that were developed by Potras. It would have been critical for all stakeholders to raise awareness on those guidelines, because our children were interacting online, they were operating online as they were learning, and there were so many issues that they were dealing with, which would have been prevented or protected even based on the guidelines. So those are some of the issues that I think we need to think about when we think about the importance of digital rights. But also even with regards to the political landscape, we have people that are campaigning online, and we have seen even more recently during the 2018 elections, how online gender-based violence, particularly towards female politicians, was on the rise. So these are all issues relating to digital rights and the political landscape that we need to think about. So what really I'm driving at, Tulani, is that the entire facets of our societies are centered on digital rights. They are centered on the digital landscape. And when we think about that from a health perspective, like during COVID-19, where even the information, the statistics was being shared online, a health perspective, an education perspective, a business perspective, a political perspective, economic perspective, we appreciate that broadly, digital rights are quite important.
And digital rights are basically in each and everything that humanity is doing now, because the world is going the world is going digital. Well, still on that, Ms. Simanje, a practical question I would like to ask is, so now, currently in Zimbabwe at this present moment, if there's a violation of digital rights, what recourse does the ordinary Zimbabwean who's listening to legal matters have right now? Can they look for a brilliant lawyer and go to court and enforce those rights or protect those rights? Or it is not yet possible to enforce digital rights within the High Court of Zimbabwe or within any other court in Zimbabwe for that matter?
It is actually quite possible. It is very possible. Like we said, that there are human rights that we have offline. So they are also protected. We have existing pieces of legislation that protect some forms of violations that people face online. Our Criminal Law Codification Reform Act is there. I think one of the key issues maybe that the Cybersecurity and Data Protection Bill will provide more clarity on is the admissibility of electronic evidence. I think that is the gap that was quite existing in our criminal justice system. So that is one aspect maybe that might need to be attended to.
Yes, on the issue of electronic evidence, most people may not understand what that is, but basically what we're trying to say is, will you be able to admit WhatsApp messages, Facebook messages, Instagram messages in court as evidence of a crime that was committed, so to say?
Yes, definitely. We have seen some people even in domestic violence cases making reference to some of those messages and the likes to prove their case. So we have seen them being at work, but I think the cybersecurity law will then provide more clarity because it has a specific provision on the admissibility of electronic evidence. So at the moment, that is one aspect which the bill will need to address and which is quite critical. But so long there's been a violation of your right, the existing piece of legislation that are there, not only through the criminal law code, but also even in other pieces of legislation like the Entertainment and Censorship Controls Act. It's there also to provide against some of these violations that are quite prevailing on the digital space.
Okay. Well said, Ms. Simanje. Well, it has really been an interesting show. It has really been insightful. And thank you just for the examples that you're giving that are common to each and every individual who was listening to the show on a daily basis. So, Ms. Simanje, thank you so much for availing your time for legal matters so that we could get to the issue of digital rights, so that we could have this icebreaker show as we explore more issues that are around digital rights, and also just get to raise the awareness with regards to how people can enforce, protect, and promote their digital rights in Zimbabwe. Just before we round up the show, do you have any last words or any parting words that you would wish to give out there to our listeners today?
I think in light of our heavy reliance on the internet and how we are operating online most of the time, I'd want to just highlight that digital safety and security is quite important. On the 21st of October, it was Global Encryption Day. And so as we think about digital rights, as individuals, we also need to think about our digital safety and security. Thank you.
Yes. Thank you so much, Ms. Simanje. And that's right. We really need to move to a time where we conscientize people and realize the importance of cybersecurity and data protection, where we move to understand that we're now living in a digital world. And each and everything we do in line is leaving a digital footprint. So be it the right to be forgotten, the right to privacy, the right to non-discrimination, digital rights encompass and cover all of them. So listeners, thank you so much for joining me today for this exciting and interesting show with Ms. Simanje as we're talking about digital rights. My name is Tulani Mututa, orator for the law. Please do catch me next week on Legal Matters as we continue with the exciting and topical conversations as we communicate for change under Heart and Soul Broadcasting Services. So enjoy the rest of the week, stay tuned, and stay legal wise. Thank you, Ms. Simanje.